Can a son stop his own father from evicting him simply by claiming that the house is ancestral property? Can a plea of coparcenary rights override the protection granted to senior citizens under the Maintenance and Welfare of Parents and Senior Citizens Act, 2007? And if an elderly parent approaches the authorities seeking protection from harassment within his own home, will the law protect the parent or the child claiming a share in the property? These are not hypothetical questions. They arose in a real dispute that travelled from a maintenance tribunal in Rajasthan to the Rajasthan High Court and ultimately reached the Supreme Court of India. During the hearing, the Supreme Court reportedly expressed its concern in strong words. Justice Vikram Nath is reported to have remarked to the son, "What kind of a son are you? Fighting with your own father? Go and take care of your father. Let him live in peace for whatever remainder period of his life." The Supreme Court then declined to interfere with the eviction order passed in favour of the elderly father. But does this mean that every son claiming ancestral property can now be evicted? Has the Supreme Court changed the law relating to ancestral property and coparcenary rights? Or has it simply reaffirmed the protection available to senior citizens under the law? In today's video, we shall separate legal fact from popular misconception. We shall examine the complete litigation, from the Maintenance Tribunal to the Supreme Court, understand what the court actually decided, what it did not decide, and analyze the legal principles that every senior citizen, advocate, law student and family should know. Friends, I am happy that our channel has completed 1 lakh subscribers and has received the YouTube Silver Creator Award. Thank you for your continuous support. For more legal awareness videos, subscribe to the channel free of cost. You may also support the channel by taking a membership of 59 rupees or 119 rupees through the GPay QR code displayed on the screen. Thank you for your continued trust and support. Now, let us turn to today's important legal discussion. This video discusses the Supreme Court case Ramesh Kumar Soni v. Sampat Raj Soni, SLP, Civil, number 2112 of 2026, which has since been dismissed by the Supreme Court. The matter was heard on 4th June 2026 by a vacation bench of the Supreme Court comprising Honorable Mr. Justice Vikram Nath and Honorable Ms. Justice V. Mohana. To understand why this case has attracted attention across the country, we must first examine the facts. The dispute related to a residential property situated at Bilara in Rajasthan. According to the father, he and his wife had been residing peacefully in the house for several years. He alleged that his son and daughter-in-law, who had earlier been living separately, subsequently entered the premises and began creating an atmosphere that disturbed the peaceful life of the elderly couple. The father alleged persistent harassment, repeated demands for money and continuous interference with his peaceful enjoyment of the property. He also referred to criminal complaints and other disputes arising between the family members. Feeling that his dignity, security and peaceful residence were under serious threat, the father approached the Maintenance Tribunal Sub-Divisional Officer, Bilara, by filing Maintenance Application No. 01 of 2023 under the Maintenance and Welfare of Parents and Senior Citizens Act, 2007. At this stage, it is important to appreciate the nature of the proceedings. The father did not file a civil suit seeking a declaration of ownership. He did not ask the tribunal to partition the property. Nor did he seek a final adjudication of title. His grievance was much narrower. He sought protection available to him as a senior citizen under a welfare legislation enacted by Parliament to ensure that elderly parents are able to live with dignity, safety and peace. The son, however, strongly opposed the proceedings. His defense was founded principally upon property law. According to him, the property had originally been purchased in the name of his grandmother. On that basis, he contended that it possessed the character of ancestral or joint family property and that he had acquired rights in it as a coparcenary. His submission was that complicated questions relating to ownership, inheritance and coparcenary rights could not properly be decided in summary proceedings before the Maintenance Tribunal. This defense raises an important legal question. If a son merely claims that the property is ancestral, does that claim by itself prevent the competent authority from granting protection to a senior citizen? Or can the tribunal still intervene where the circumstances indicate that the welfare and peaceful residence of the elderly parent require immediate protection? The Maintenance Tribunal carefully considered the rival contentions and the material placed before it. After examining the circumstances, the tribunal concluded that intervention had become necessary for protecting the senior citizen father. Accordingly, by its order dated 8 February 2024, it directed the son to vacate the premises. Naturally, the son was dissatisfied with this decision. He challenged the tribunal's order before the Rajasthan High Court by filing SP Civil Writ Petition No. 5263 of 2024. The principal argument before the High Court remained substantially the same. The son contended that the dispute essentially related to title, inheritance and coparcenary rights, and that such issues could not be decided in proceedings under the Senior Citizens Act. The father, on the other hand, maintained that he had not approached the tribunal for adjudication of ownership. His case was that he required statutory protection to enable him to live peacefully in his own residence. After considering the rival submissions, the Rajasthan High Court examined the object and purpose of the Senior Citizens Act. By its judgment dated 21 April 2026, the High Court declined to interfere with the order of the Maintenance Tribunal and upheld the protection granted to the elderly father. Still aggrieved, the son approached the Supreme Court of India by filing a special leave petition. The matter recently went all the way up to a Supreme Court vacation bench, where the judges completely slammed the son's conduct. This brings us to the most important stage of the litigation, and to the legal principles that every advocate, law student, senior citizen and litigant should clearly understand. Many people believe that once a matter reaches the Supreme Court, the court is expected to examine every issue in detail and pronounce upon every legal contention raised by the parties. That, however, is not the correct legal position. The son's petition before the Supreme Court was a special leave petition under Article 136 of the Constitution of India. This distinction is extremely important. Article 136 does not confer an automatic right of appeal. Unlike a statutory appeal, where a litigant may have a legal right to challenge a decision before a higher court, a special leave petition invokes the extraordinary discretionary jurisdiction of the Supreme Court. In simple terms, the Supreme Court first decides whether the case deserves its intervention at all. Even if another legal view is possible, the Supreme Court is not bound to interfere. The court ordinarily exercises this extraordinary jurisdiction only where substantial questions of law, grave injustice or exceptional circumstances justify its intervention. This constitutional principle is often overlooked in public discussions. Consequently, whenever the Supreme Court dismisses a special leave petition, many people immediately conclude that it has finally decided every legal issue involved in the case. That assumption is not always correct. Keeping this constitutional background in mind, let us now examine what transpired before the Supreme Court. The son's counsel reiterated that the dispute was essentially one relating to ownership, inheritance, and coparcenary rights. It was argued that the property possessed the character of ancestral or joint family property and that such disputed questions of title could not be finally adjudicated in proceedings under the Maintenance and Welfare of Parents and Senior Citizens Act, 2007. It was also submitted that eviction would adversely affect not only the son but also his wife and children residing in the premises. The father's case, however, remained consistent throughout the litigation. He maintained that he had approached the statutory authority only because his peaceful life had become impossible. His request was not for a declaration of ownership. Nor did he ask the tribunal to determine the ultimate title to the property. He sought only the protection which the law extends to senior citizens whose dignity, security, and peaceful residence are under threat. During the hearing, the bench expressed concern regarding the unfortunate dispute between a son and his elderly father. According to reports of the proceedings, Honorable Mr. Justice Vikram Nath made the following observation. What kind of a son are you? Fighting with your own father? Go and take care of your father. Let him live in peace for whatever remainder period of his life. Ultimately, after considering the matter, the Supreme Court declined to interfere with the concurrent orders passed by the Maintenance Tribunal and the Rajasthan High Court. The special leave petition was dismissed. Now comes the most important question. What exactly is the legal significance of this order? Unfortunately, several social media posts and even some news reports created the impression that the Supreme Court had delivered a landmark judgment changing the law relating to ancestral property. With great respect, that is not the correct way to understand this proceeding. The Supreme Court did not declare that every son claiming ancestral property can be evicted. It did not hold that coparcenary rights have ceased to exist. It did not amend or reinterpret the principles governing ancestral property under Hindu law. Nor did it pronounce a detailed judgment laying down a new rule of property law. Instead, the court simply declined to interfere with the protective orders passed in favor of the senior citizen father in the peculiar facts and circumstances of this case. This distinction is not merely technical. It is fundamental to understanding our constitutional system. The Maintenance Tribunal was exercising jurisdiction under a welfare legislation enacted to protect parents and senior citizens. A civil court, on the other hand, decides questions relating to ownership, partition, inheritance, succession, and title. These are two different jurisdictions serving to different purposes. Proceedings under the Senior Citizens Act are primarily intended to secure the welfare, dignity, and peaceful residence of elderly parents. Civil proceedings determine proprietary rights. One does not necessarily exclude the other. Suppose an elderly father alleges that he is being continuously harassed and is unable to live peacefully in his own house. If the child merely replies, "The property is ancestral," and that assertion alone was sufficient to defeat proceedings under the Senior Citizens Act, the very purpose of the legislation could easily be frustrated. Every person against whom proceedings are initiated would simply raise a plea of ancestral property or coparcenary rights. The protective object of the statute would become largely ineffective. The law, therefore, adopts a more balanced approach. It recognizes that genuine disputes regarding title, ownership, or partition may certainly be decided by competent civil courts. However, the mere assertion of such rights does not automatically prevent the competent authority from granting appropriate protection to a senior citizen where the facts justify such intervention. This is the broader legal significance emerging from the present proceeding. Another constitutional aspect also deserves attention. Article 141 of the Constitution provides that the law declared by the Supreme Court is binding on all courts in India. The important words are law declared. A reasoned judgment laying down a legal principle ordinarily becomes binding precedent. However, the dismissal of a special leave petition, particularly where the court has not delivered a detailed judgment declaring a principle of law, does not ordinarily amount to a declaration of law under Article 141. That is why it would not be legally accurate to present this proceeding as creating an entirely new rule governing ancestral property. At the same time, this does not diminish its practical importance. The proceeding reflects the consistent judicial approach of ensuring that the provisions of the Maintenance and Welfare of Parents and Senior Citizens Act, 2007 are implemented in a manner that effectively protects elderly parents. It also sends a clear message that property disputes should not become instruments for making the lives of senior citizens miserable. The dignity of elderly parents deserves meaningful legal protection. That is the humanitarian philosophy underlying this legislation. But there is another equally important lesson that emerges from this case, and every advocate, law student, litigant, and family should remember it. The law does not encourage unnecessary conflict within families. Whenever possible, disputes relating to family property should be resolved through dialogue, mutual respect, and lawful settlement rather than prolonged litigation. Parents and children are not adversaries by choice. They are members of the same family. Unfortunately, when relationships deteriorate and legal intervention becomes unavoidable, the courts are required to strike a careful balance between competing legal rights. On one hand are the legitimate civil rights that a person may claim in respect of property. On the other hand is the statutory obligation of the state to protect elderly parents from neglect, harassment, and insecurity. The law does not sacrifice one for the other. Instead, it attempts to harmonize both. A genuine dispute regarding ownership, partition, or inheritance can always be adjudicated before the competent civil court in accordance with law. However, such disputes cannot ordinarily be permitted to become a justification for depriving senior citizens of their right to live peacefully and with dignity. This balanced approach has become a consistent feature of judicial decisions interpreting the Maintenance and Welfare of Parents and Senior Citizens Act, 2007. For senior citizens, this proceeding carries an important message of reassurance. The law is not helpless. If an elderly parent is genuinely subjected to harassment, intimidation, or circumstances that make peaceful living impossible, the statutory framework provides remedies that can be invoked for protection. For children, the message is equally important. If you genuinely believe that you possess legal rights in a property, assert those rights before the appropriate legal forum. Property disputes should be resolved through lawful proceedings, not through conduct that disturbs the peace, dignity, or security of elderly parents. For advocates, this case serves as a reminder that every legal proceeding must be understood within the limits of the jurisdiction being exercised. A proceeding under the Senior Citizens Act is not the same as a civil suit for declaration of title. Similarly, a special leave petition under Article 136 is not the same as a statutory appeal. Understanding these distinctions is essential for accurate legal analysis. For law students, this case offers a valuable lesson in constitutional law and statutory interpretation. It demonstrates the importance of reading judicial orders carefully, appreciating the scope of different jurisdictions, and avoiding conclusions based solely on headlines or brief media reports. In today's digital age, legal news often spreads rapidly through social media. Unfortunately, speed sometimes comes at the cost of accuracy. A single headline stating that the Supreme Court dismissed the son's petition does not explain why the petition was dismissed, what legal issues were involved, or whether the court declared any new principle of law. As lawyers and informed citizens, we must always go beyond headlines and examine the legal context. That is precisely the objective of this channel. Our endeavor is not merely to report legal developments but to explain the law in a manner that is accurate, balanced, and easy to understand. Before we conclude, let us briefly summarize the key legal principles emerging from today's discussion. First, the dispute arose under the Maintenance and Welfare of Parents and Senior Citizens Act, 2007, a beneficial social welfare legislation enacted to protect the dignity, welfare, and peaceful living of parents and senior citizens. Second, the father approached the Maintenance Tribunal seeking statutory protection. He did not institute a civil suit for declaration of ownership or partition of the property. Third, the son resisted the proceedings by claiming that the property was ancestral or joint family property and that he possessed rights as a coparcenary. Fourth, the Maintenance Tribunal granted protection to the senior citizen father and directed the son to vacate the premises. The Rajasthan High Court upheld that order. Fifth, the Supreme Court, while exercising its discretionary jurisdiction under Article 136 of the Constitution, declined to interfere with the concurrent orders passed by the authorities below. Sixth, this proceeding should not ordinarily be understood as a landmark judgment changing the law relating to ancestral property or coparcenary rights. Nor should the dismissal of the special leave petition be treated as a declaration of law under Article 141 in the absence of a reasoned judgment laying down a new legal principle. Finally, the proceeding reinforces an important judicial approach that the welfare, dignity, and peaceful residence of senior citizens deserve effective protection and that property disputes should not ordinarily become instruments of harassment against elderly parents. Friends, every legal dispute ultimately concerns human lives. Behind every case number lies a family. Behind every judicial order lies a human story. The law performs its highest function when it protects both justice and human dignity. The Maintenance and Welfare of Parents and Senior Citizens Act, 2007 reflects that philosophy. It reminds us that respect for parents is not merely a moral value but, in appropriate cases, a concern that the legal system is prepared to protect. At the same time, the law continues to preserve the right of every person to pursue genuine civil remedies relating to ownership, succession, or inheritance before the competent forum. That careful balance between welfare and legal rights is the true message emerging from this proceeding. I hope today's discussion has helped you understand not only what the Supreme Court did, but also what it did not decide. If you found this analysis useful, please like this video, share it with your friends, colleagues, advocates, and law students, and subscribe to Legal Information Law Insights for more well-researched legal awareness programs. If you wish to support our mission of promoting legal literacy, you may also become a channel member through the membership options displayed on your screen. Your encouragement enables us to continue creating accurate, educational, and socially meaningful legal content. Now, I would like to hear your opinion. Do you believe that the existing provisions of the Maintenance and Welfare of Parents and Senior Citizens Act, 2007 provide adequate protection to elderly parents? Should Parliament strengthen the law further, or do you think the present legal framework strikes the right balance between the rights of senior citizens and the property rights of their children? Thank you for watching this video. I hope this discussion has helped you better understand the scope and practical utility of the Senior Citizens Act, 2007. If you found this information useful, please like the video, subscribe free of cost, and share your views in the comments. For more legal insights, do not forget to press the bell icon. I shall meet you again soon in the next video. Jai Hind! Jai Bharat!